Well, good morning, everybody. We'll kick off the meeting and welcome and turn it over to Kay, who's the litigation director for New Hampshire Legal Aid. Kay, do you want us to hold questions to the end or kind of chime in as you're presenting?
No, we said we were gonna hold questions till the end.
Okay. All right. You have a presentation, and I think Brandy's going to share her screen, and then we'll kick it off. Thank you.
Thank you very much. I hear a little bit of there. That's great.
Did it do it?
You have to mute yourself.
We should probably all mute.
Great. Thank you very much. Going to do is I'm just going to, with Brandy's help, take you through a number of slides that are intended to just really raise your consciousness even more about what are the problems of low-income people in this area and how can we work together to address those problems. And even though we're having this presentation during the COVID-19 pandemic, the basic principles that I'm going to talk about apply at any time. And so even though we're in the middle of a pandemic, the same responses would apply, you know, looking at a denial notice very carefully, measuring out how much time there is to appeal that notice. I will talk a little bit about resources that New Hampshire Legal Assistance has put together for this time, and I'll refer you to those. And then at the end, when we take questions, you can of course ask me any questions that you have about this time in our shared history or any general questions. So New Hampshire Legal Assistance, many of you already know about. We only handle, let's go back to the previous slide, Brandy. We skipped over who I am. So this is who I am very clearly for you. I work in Portsmouth, so that means I can, you know, cover the Rockingham, Stratford, Carroll County cases to the best of my ability with people in my office. I also work statewide as a litigation director for New Hampshire Legal Assistance. We only handle civil cases. So we're somewhat like the public defender in terms of who our clientele is. We only represent low-income people. But unlike the public defender, which handles criminal cases, we handle civil cases. And we focus on what we call subsistence cases. So someone who's about to be evicted from public housing, that is our client. Someone who's gotten a Medicaid denial, that is at least potentially our client. If someone calls to us for help who is a higher income person, we will refer them to private attorneys who are able to assist them. So many of you work with Medicaid patients. They are the group that we also work with. And then you also may do some pro bono cases, cases where you're helping low-income people. You may be getting requests for help from family members of your client. You know, you may just find out that your client's daughter just got an eviction notice from public housing and your client is really worried. So those are the kind of cases that we would like you to bring to us. So the next slide explains just the 7 topics that we're going to go over this morning, and it's somewhat of a kind of whirlwind introduction to a number of legal topics, as well as just important points that I'd like you to be aware of. So Brandy, if you could, when you have a moment, show our 3rd slide.
She will in a minute. She's having some technical difficulties.
Okay, so I'm gonna, okay, again, Brandy, I really appreciate it. I'm sure if I was doing 3 different things this morning, I would not be smiling as much as I am right now. So I'm gonna go through and tell you what the topics are that I'm going to talk about. The first topic is just how do I apply for free legal aid in the state of New Hampshire, so that you don't have any question when you're meeting with a client in the campground, at your office, when someone calls you when you happen to be in your office at night and says, I really need legal help, you can instantly go into action and help them apply for legal services. Let's just give Brandy a moment. Okay. Thank you so much, Brandy. So the second, so let's just go back to the previous slide, as if we could. Thank you very much, Brandy. So then second, Legal Aid in New Hampshire has a blog where we tell you, here is what we know as of today for how to apply for stimulus checks, for instance, whether tenants can be the subject of court eviction proceedings this month. So we have one place with all that information, and I'll show you where that is. Then how do you recognize when something is a legal problem, and how can you identify timeframes for low-income people to protect their legal rights? So those are just really basic, how do you work with the people that you're in contact with already to get them the legal help that they may need. And then the last 3 topics are just to help you get some ideas about some of the work that we do that really may overlap with what you do. And so the 5th topic is just basically an introduction to what does local welfare do in New Hampshire. You may have had people apply for help from the city and come back and told you various things. And so I'll give you a brief introduction to that topic. And then I'm going to talk about some of our efforts that I think you would readily relate to, our Medicaid work requirements lawsuit, and then a Choices for Independence investigation. Okay, so that's what we're going to do in the next half hour or so, which is pretty ambitious. So going to the next slide then, Brandy. So how to apply for free legal aid. The Legal Advice and Referral Center is our sister agency, and it is set up to do screening, referral, and counsel and advice. And beautifully, it has 24/7 online application. So, and I think Brandy will share these slides with you, so you'll get this information in writing. Is that correct, Brandy? I think that I'll certainly share them with you, so you don't have to write everything down. So at nhlegalaid.org, you'll see a button that says apply for legal help or apply for legal services. And then, so Kelly's just confirming that you'll all get the slides from her. Thank you, Kelly. So if you're in a campground with a smartphone and somebody says to you, I just got this Medicaid termination notice, you can just sit there with your smartphone, go onto this website and apply for the person you're with. And when I do this for somebody, like I might just get a random caller who wants help with a family law case that I know is not going to be accepted by New Hampshire legal assistance, I will fill out this application for the person, and then I'll say at the end, this was completed by Drought at New Hampshire Legal Assistance as a courtesy. So you could do that as well. And then the person that you're helping just has to have a phone contact information, because the Legal Advice and Referral Center will see that application and call the person back. So if the person doesn't have a phone, you'll have to figure out some alternative contact. But as long as they have a phone, you just send that application off, and then the Legal Advice and Referral Center will see that application. If it's a case that legal assistance handles, the Legal Advice and Referral Center will just ship that case to us quickly. So you don't have to wait on the phone to talk to anyone. And you just have to answer about 19 or so pretty simple questions about where the person is and just the gist of what they need help with. If you can take a picture or scan the termination notice that you're looking at, all the better. That's really helpful. So again, that can be done anywhere as long as you can connect with that website. If you're doing regular business hours, you can call the LARC number, and if you have someone who prefers to do that, that's fine as well. It's never wrong to contact LARC to apply for legal help. And then secondly, the next slide, please. If you're working with somebody who has an urgent legal problem, a local welfare problem, and this is something that you know from my talk today that legal assistance handles. Like you have a homeless family of 6 in your office who says, we just went to the city told us to go back to Pittsburgh, Pennsylvania, where we were last month, and won't help us at all. Like, that is a huge emergency. And that is the kind of case that legal aid handles. So if it's during regular business hours, our phones are open and you can contact us directly on that kind of local welfare case. And if you're not sure who to call, LARC or New Hampshire Legal Assistance, you know, either one is fine. They will redirect you. Those are the ways to apply for free legal aid in New Hampshire. It takes you, a moment or two to set things up for your client. Oftentimes a social worker will call us and just say, I'm handing the phone to so-and-so and I'm leaving the room so you can talk confidentially, or so-and-so would like me to stay here with them. They have a traumatic brain injury and I help them communicate. And so that's fine, whatever whatever best expedites your person's request for legal aid. The next slide just gives you our website, and this is the community guidance that we have for COVID-19 resources. The governor and the courts have issued a series of orders, as you know, and then there's also federal guidance on lots of subjects. So New Hampshire Legal Assistance has project directors in various practice areas such as housing who have put these guidelines together. So if you're working with someone who says, hey, I don't know what's going on with Social Security right now, you can go to that blog and you can read, oh yes, you know, the offices are closed, but they are answering their phones, and you can just give your client some guidance about what's happening. Okay, so then we'll go to our next topic, which is beginning to identify what is a legal problem. So some legal problems are pretty darn obvious, like the person gets the eviction notice from public housing saying, you know, because of noise conditions in the apartment, you're being evicted. So that's a written eviction notice spelling out very dire consequences. So that person still may not contact New Hampshire legal assistance right away, even though that's really, you know, a pretty alarming situation to be in. So one way you can help us is by encouraging them to ask for legal help right away, because every week we get people who contact us late in the game, and so it's a harder situation for us to try to resolve. We like to hear about legal problems early and often, but it may be a legal problem that's harder to identify, such as your person needs gas to get their children to medical appointments and also is behind in the rent. Well, the person applied for help from city welfare, and wonderfully city welfare paid all the rent, but said we don't help at all with transportation. Well, that's still a legal problem because transportation is a subsistence legal need, a subsistence need of the individual, let me say that. And so it is a legal problem that the person's request for local welfare help for transportation was denied. So they'll look at whether the person's very basic needs are met or not. And then if the individual's needs are not met, we ask, have they already applied for help? And that will be the next slide, please. And so we ask, has the person applied in writing for help from the right government agency or agencies? Because if the person had a phone conversation and was told, hey, we don't help with that, there's no record that they made the application. There's no record that their request for help was denied. So, and everyone is human. So occasionally the best intended government agency may give out erroneous information, but at a minimum, the agency may have a very different idea than we do at legal assistance about what someone is entitled to. So we like people to apply in writing. If we get a phone call, for instance, from an individual saying, I called local welfare and I was told that because I was helped last year, I won't be helped this year, we will say, please apply in writing and get a written decision. If we may intervene before that happens, but we really need people to make written applications for the help that they're even in the ballpark of being entitled to. And then the next slide, what did the agency respond? And we look very carefully at the written notice, which requires some focus and concentration because the notice may be hard to understand. But we look at, was that decision in any way unfavorable to the individual? Like the Social Security Administration could find that someone is entitled to disability benefits, but only going back 1 year when they were seeking disability benefits for 3 years retroactive. So even though the decision is overall positive, they would want to consider whether to appeal on the lack of 2 years of retroactive coverage. So an outright denial or termination is pretty easy to identify that that's an unfavorable decision, but a reduction in benefits where they're still receiving benefits or getting only some of what they asked for are also unfavorable decisions that can be appealed. So then the next slide shows that we also are interested as lawyers in whether the agency failed to issue a timely decision. If you have someone who is homeless and needs emergency food stamps, are they still waiting days later to get those SNAP benefits? Do you have someone who got a 7-day demand for rent saying your rent must be paid in full plus $15 in 7 days, and then local welfare said, oh, we don't have any appointments until next month? That's a problem because the agency's actions in scheduling help is alleged help is thwarting the person from getting the help that they need. So that's a legal problem. The government assistance has to be timely, and how timely really depends on what law is involved and what their needs are. But you can get a pretty good just common sense idea when you look at the notice and assess the person needs. Are they being just kept languishing, waiting? And that's a situation, we don't even want them to get to the languishing part. If they're even beginning, we'd like to hear about it. So then we'll talk about what to do when you're in a situation, next slide please, where you hear about a decision that looks problematic. And so I'll just wait for a moment, Brandy, to have the slide catch up with us. Okay, right. So if the decision is in any way unfavorable, it's time to think both about appealing the decision and about contacting legal aid. If the individual cannot get a timely decision, it's time to contact legal aid. And you, of course, will be using your judgment to work with your person about this. You may be working with a domestic violence survivor, for instance, and say, it looks suspicious you're getting some SNAP benefits, but not as much as I think you should be getting. And the person tells you, I'm really just focused on getting a protective order right now. I really need to just think about my safety. The notice says I have 7 food stamps. It's a very long appeal period. So if the person tells you, I'm really just not able to focus on this right now, that's understandable if they're getting some benefits, just not what you think they should be getting. But, always identify what the deadline is so that you and they know, well, once they get their protective order, it's time to go back and look at the amount of SNAP benefits. So we're not saying that everybody needs to appeal each and every decision that is in any tiny way unfavorable, but just be open-minded and evaluate each unfavorable decision to see what's at stake and what the deadline for appeal is. Next slide, please. So identifying deadlines, as we've talked about already this morning, read the notice, try to understand what the notice says, determine what the appeal rights are and what the deadline for appeal is, seek free legal services for the individual right away. So if your person comes to you right away, like the day the person got the eviction notice, or the day they got the Social Security denial or the Medicaid termination, you know, that's a relatively more comfortable situation. You know that you are able, you know, to get them legal help, you know, right away, the same day pretty much that they got the decision. But if you see on the notice that it's about to expire, it's a Medicaid termination notice from the Department of Health and Human Services, and the person brought it to you the day the right to appeal expired, really read the notice and help the person themselves make an appeal to the administrative appeals unit. The person can do that by phone or in writing. And, you know, when you help the person apply for legal aid from the Legal Advice and Referral Center, you will get an email back saying, you know, please do what you need to do basically to protect your legal rights in the meantime, because you're not necessarily going to get an advocate who can, in half an hour, you know, file a request for a fair hearing for the client. So you need to be poised to do that yourself when you see that the deadline is about to expire. So next slide. So this is a very important concept. The previous slide. If the person is already receiving benefits, they're in a much better position legally than someone who's trying to get on benefits. If somebody is already receiving benefits and receives a notice of reduction or termination of benefits, the person can seek benefits pending appeal. That means they stay on benefits until a hearing officer makes the decision about whether or not they're eligible. So when you're looking at a notice, the deadline to request benefits pending may be faster than the decision, than the deadline to appeal itself. It may, for instance, be 15 days from the date of the notice of decision if you want to request benefits pending appeal, but 30 days in which to appeal. So you want to make sure that the person you're working with makes that quicker deadline to request benefits pending. Then, as we say, the status quo remains, the person is stable, the person's benefits are on until the hearing officer makes a decision. This applies to all different kinds of benefits. It could apply if local welfare has paid to keep someone in a motel accommodation and then decides they're suddenly ineligible for continued motel accommodation. The person can request benefits pending appeal. Technically, the person risks having to repay those benefits in the event they're still found ineligible, and in the event, you know, they actually have an ability to repay. But for us, for the most, in the vast majority of situations, it's much better to keep the person on benefits. And that way, you have a more relaxed way in which to work with them or seek legal advice for them. You don't have to worry that their coverage has been terminated. Next slide, please. So it seems like social workers and others may have really good relationships with DHHS, which is great. So when they see a denial notice or a notice in reduction of benefits, their instinct may be, I'm going to call this caseworker who I know and see if I can get that person to reassess the situation, which is great if it happens, but it's not great if the person blows the appeal deadlines and your friendly contact is suddenly unavailable. So I just want to assure you that legal assistants frequently request fair hearings for clients, and then we go on to settle the case. So it's not one or the other. And next slide, please. We also find that once we file an appeal for someone, we may actually have more leverage because we, the Department of Health and Human Services, for instance, or local welfare, may not want to go through, what could be a 3-hour fair hearing. So they're going to take definitely a second look at what has happened and see if they want to reassess their position. So with that, I've gone over really the basics of how to work with your clients to just kind of get a sense of whatever government decision is affecting them and get help from New Hampshire legal assistants applying for help through the Legal Advice and Referral Center. If you do that, there's a very high likelihood that the person will at least get some counsel, advice, and guidance. So they'll be in good shape, compared to where they were before. And at most, legal assistants or a pro bono lawyer will be able to represent them in court for no fee to the client. So that's really a great service that is available. So then I'm going to move on to my next topic, which is local welfare. Now, this is very mysterious to many people, including most people in the legal profession. And you may think, is it charity? Is it just what happens with excess municipal funds? But it's neither. So local welfare is really the duty of each town or city in the state. So hundreds of different municipalities each have that duty, whether it's the city of Manchester or the town of Ossipee. It's one of our oldest laws that's been part of the New Hampshire legal landscape since colonial times. And it's actually a set of state laws, state statutes that you can find where I have given you the reference on the general court website. It's a set of about 22 separate short laws that all are integrated. So next slide will tell you just what is local welfare. So I'm going to read this to you. It's dated language. Of course, this is hundreds of years old. Whenever a person in any town is poor and unable to support himself, he shall be relieved and maintained by the overseers of public welfare of such town, whether or not he has residence there. So those are the eligibility criteria: poor and unable to support themselves. And what the person needs is to be relieved and maintained. So those are very broad terms. Someone with agoraphobia may need to be relieved and maintained in a way differently from somebody who does not have agoraphobia. Someone with infant twins may need to be relieved and maintained in a different way than an elderly couple. So the word relieved really means emergency help. So if the person is at risk of eviction, at risk of homelessness, they need emergency help. But the word maintained means that the person needs to be kept in place. So it's not a time limited kind of help. And there are some people who are waiting on federal disability benefits who may need local welfare assistance for some time, not just 1 week or 1 month. I also want to draw your attention to the last 7 words, whether or not he has residence there. So there's no residency requirement for local welfare. If someone comes from Berlin to Manchester and happens to be in Manchester today and isn't and doesn't have anywhere to stay, that person can apply for local welfare in Manchester, and the city of Manchester does not have the legal ability to say, take the bus, back up to Berlin. Of course, if the person says, I want to go back to Berlin, I want to go back to Berlin right away, but I don't have anywhere to get there, then they can work out an arrangement, but it's the person's choice that that's what they want to be relieved and maintained, is to get back up to Berlin. But we see many situations where one town says, you're not a resident here, so we won't help you. You came from Michigan last month. Well, that's not a legal reason to deny help. So if you're aware that the law, the actual local welfare law, says whether or not he has residence there, that is helpful if you're working with somebody who's been denied on that ground. Cities do have ways to recoup the money that they spend for local welfare. If someone has a home, for instance, that they own, they may have a lien put on the home. If they're getting federal disability SSDI in the future, they may have to repay some of the general assistance they received. So the municipality, it's not solely a one-way stream of income. There is some reimbursement to the town. So then the next slide. So municipalities have their own guidelines, and the guidelines cannot conflict with the state law. So this is a point that's often misunderstood. You just saw the state law. It says a town has to relieve and maintain. It doesn't say, but a town never has to give transportation help. So if a town has a guideline that might be from 2002 that says we never provide help with transportation or help with back rent or help with back utility bills, those guidelines conflict with the state law and so are not legal. And so if somebody actually needs transportation assistance to be relieved and maintained, we would say the town must give that transportation assistance. You may well know that towns do not give cash to individuals. If somebody needs $40 to get to the medical appointments, the town will provide a voucher made out to a gas station that the town has set up an arrangement with. So the local welfare recipient has no discretion about where to spend the money. If it's a grocery store voucher, of course, the recipient would have some discretion about whether to buy this type of milk or that type of milk, but the vouchers are made out to whoever is actually providing the service or the good to the local welfare recipient. So that distinguishes local welfare from many, many other kinds of public assistance. So let's go to the next slide. So local welfare is for subsistence needs. So if you have a client who really wants help getting to the grandma's funeral in Anchorage, Alaska, that's something to ask a charity to help with. That's not something to ask local welfare. But housing, utilities, transportation, food, those are examples of local welfare responsibilities. Oftentimes, if somebody has a demand for rent, they may go to a church or a synagogue, they may ask for charity help. And really, if local welfare has a legal responsibility, it's really important to apply for help from local welfare and tell legal assistance if the person isn't getting their basic subsistence needs in a timely notice of decision. We've talked about this already, that local welfare assistance must be timely. Local welfare guidelines actually allow local welfare to provide emergency assistance. So the same day that someone appears for their first local welfare appointment, they can leave the office with a voucher for motel accommodation. Often they don't even have to get a physical voucher. The local welfare can just make arrangements directly with the motel. Of course, local welfare is for subsistence needs. So if there is shelter accommodation available, and if the shelter accommodation is appropriate for the individual, that is permissible. And there are individuals for whom shelter accommodation is not appropriate. You know, the person with agoraphobia, whose medical provider has opined that the person cannot be, in close quarters with certain numbers of individuals, or the person with other medical needs for whom shelter accommodation is not appropriate. Local welfare assistance has to be timely, as we've discussed. We've also had cases where local welfare is inclined to separate a family, like have the man stay in a men-only shelter and with the oldest child, the oldest boy child, and then the mom and 3 younger children stay in a family shelter, regardless of the fact that the mom works nights, for instance. And so even if the mom did not work nights, we would say that the family is a family unit that needs to be sheltered as a family unit, not separated. Next slide, please. So this is really a very key point that we want everyone to understand, and is likely happening now more than ever. If a tenant gets behind in rent, the tenant is very, very vulnerable to being evicted, because the landlord can issue a 7-day demand for rent and eviction notice. So that's a really short time period. So if you're working with someone who hasn't paid May rent, and today it's May 5th, that person can today get a notice saying unpaid May rent of $900 must be paid by May 15th plus $15. So if the landlord has written that notice correctly and the tenant does not pay by May 15th, the tenant is at risk of eviction. If the tenant does pay everything by the deadline, the tenant has cured, meaning the tenant has resolved the problem. And so when you meet the person who's just gotten this demand for rent and eviction notice asking for $915, they likely do not have $915. You know, they may have some small part of that. And so we recommend that they apply for help from local welfare right away, and that local welfare needs to meet with them well before May 15th so that any attempt to assist is really timely. So let's just say that your person comes in today with the notice to quit and demand for rent, $915. You send the person to local welfare. Local welfare sets up an appointment tomorrow, says, you know, you only have $100. We'll help you with $815 of the rent, and the extra $15 fee. Who's your landlord? And your person says, okay, my landlord is Joe Jones. The tenant will be asked to have the landlord verify what the amount is due. And Joe Jones could tell the tenant, hey, I don't accept local welfare. I want you out of here. The tenant goes back to local welfare, reports my landlord Joe won't help, and then won't even fill out the form confirming what is owed. So then local welfare calls up Joe and says, Joe, I really want to help this tenant. I'm about to pay $815. The tenant has $100. I just need your confirmation. And Joe just says, I won't accept any help from local welfare. I don't do local welfare, something like that. Well, under that scenario, the tenant has a defense to eviction because the tenant and local welfare did everything right for Joe, the landlord, to get the payment that's due. And as long as local welfare promises in writing to pay, and the tenant and the landlord gets that promise by the due date, it's good. It's as though the tenant had given a money order for $815. If the landlord thwarts that process, it's a defense to eviction, so that because the tenant did everything possible so that the landlord would get the money. So we like to hear about situations that involve this intersection between eviction law and local welfare law. And certain judges might misunderstand this and actually give some credence to the landlord's preference to not accept a local welfare voucher. But under the law, the local welfare voucher must be accepted, or else it would be a defense to eviction. Okay, so the next slide. Okay, so now I'm just going to talk about two of our efforts that are what we call impact cases or investigations. So legal assistance does a lot of individual cases. The individual whose landlord wouldn't accept local welfare, we would be interested in that case and likely screen that case in. Somebody who's been terminated from Medicaid, we would, or has not been able to get pandemic unemployment assistance. We handle all those types of individual cases. We handle cases for kids with disabilities in school who don't have their IEP being followed. So we do a wide range of individual cases, but we also do certain cases where in one case we can advocate for the rights of multiple people. And so I'll just tell you about one ongoing case that people in groups like this are wildly enthusiastic about. So it's fun to talk about. So you all understand what Medicaid is, and Medicaid has been part of our country's safety net since 1965. And the Medicaid statute says that Congress enacted Medicaid law to provide medical assistance to low-income people. So that's what Medicaid is for by federal law. it's not a work program. So next slide. Throughout recent history, I've been practicing in New Hampshire for about 22 years. There have been various threats to Medicaid. Our former governor, Stephen, was considering Medicaid block grants, and that's something that is up for discussion in the federal government that I'll talk about in a minute. So Brandy, if you could advance to the next slide as soon as you're able to. Thank you very much. So after passage of the Affordable Care Act, New Hampshire expanded its Medicaid program to include low-income adults regardless of disability. So that was fantastic. So whereas previously APTD, aid to the permanently and totally disabled, would be a doorway where people would have to prove a 4-year disability standard in order to get APTD, in order to get Medicaid. Now that disability standard was no longer a requirement for a low-income adult to be eligible for health care through Medicaid. So at any one time, about 50,000 people in New Hampshire qualified for Medicaid through this Medicaid expansion. And next slide, please. And in 2018.
I just want to give you a warning. We got a 3-minute warning.
Okay, thank you. Okay, so in 2018, suddenly the federal government decided that work requirements were a good idea for Medicaid recipients. And New Hampshire, our state government, sought and received a waiver from the Centers for Medicare and Medicaid Services to implement Medicaid work requirements in New Hampshire. And our work requirements were actually the most onerous in the country in terms of all of the states that were proposing Medicaid work requirements, 100 hours per month, and applying to people up to age 64. So even though other states like Arkansas and Kentucky also impose Medicaid work requirements, New Hampshire's was even more onerous. Next slide, please. So in March of last year, seems like much longer ago, so much has happened. So 4 New Hampshire Medicaid recipients filed a lawsuit as plaintiffs to stop Medicaid work requirements. And so legal assistance represented and continues to represent those 4 individuals, the National Health Law Program and the National Center for Law and Economic Justice, our DC and New York based advocacy groups that joined in on the lawsuit. And the National Health Law Program was the lead law firm. And next slide, please. And as you likely know from reading the newspaper, if you could show the next slide, we did win the lawsuit at both the trial court level, was in Washington, DC, the District of Columbia, and in the Federal Circuit Court of Appeals. If Medicaid work requirements had gone to an effect in August 2019, over 17,000 people would have lost health coverage in New Hampshire because work requirements were stopped for a variety of reasons, including the lawsuit, right before people would have lost coverage. And next slide, please. The Urban Institute recently wrote a report on New Hampshire Medicaid requirements, which you can, I'm sure, find on the website or ask me to send to you. So you may know that because Arkansas implemented work requirements before New Hampshire did, and Arkansas disenrolled 18,000 people, New Hampshire officials were saying to us, oh, we're not going to make the mistakes that Arkansas did. But what the Urban Institute found was that New Hampshire would have disenrolled 67% of the people subject to Medicaid work requirements after just 2 months. So the effect would have been even more draconian than in Arkansas. And of course, as you're aware from being people who work with Medicaid recipients, the people who are getting disenrolled due to Medicaid work requirements in Arkansas, they're working. They're just not able to do the compliance, or else they are disabled from work, but they're not able to prove that to the satisfaction of the Medicaid work requirement people. So just in my remaining moments, let's move to the next slide. I'm going to talk and invite you to contact me after today about the Medicaid CFI program. Choices for Independence is a Medicaid program that you're all well aware of, I'm sure. It's intended so that individuals who need help in their home get that help and do not have to move into institutional care. Next slide. When people on CFI lack the personal care services or nursing, skilled nursing, or other care that they're entitled to, they are actually at risk of institutionalization, which is what the CFI program is intended to try to avoid. So, and now the risk of institutionalization is different, more severe than it even was, 6 or 8 months ago due to COVID-19. So the final slide, please. So if you wish to talk to me in detail about your experiences with the Medicaid CFI program, I would love to hear from you. Just call me or email me and we can set up a time to talk. And if you're working with individuals on CFI who are not getting the services they need, not even the services that are in their care plan, they can contact us directly to explain that they are not receiving the services they need. So again, that is the New Hampshire Legal Assistance number.